Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Friends, you all know that the Honorable Supreme Court of India held a positive view in demonetization case. So, it has passed the test with 4-1 majority. Another constitutional judgment, another judgment by the constitutional bench yesterday came out from the same bench stating that the Prime Minister of the Chief Minister, Prime Minister in the center or the Chief Minister of a state, they do not have any disciplinary control over the other ministers. This is what is held by the Supreme Court Constitutional Bench in the case of Kaushal, Kishore versus State of Uttar Pradesh and others in WP number 113/16 delivered on yesterday, that is on 3/1/2023 by 5 judges bench. Justice Abdul Nazir, Justice B.R. Gawai, Justice A.S. Bopanna, Justice V. Ram Subramaniam and Madam B.V. Nagaratna. The important point is, even though we say as per Article 75, collective responsibility of the Council of Ministers, and if any minister does anything, then it is the collective responsibility, all the ministers are liable. Of course, Supreme Court stated that it is only a political concept. So, the Prime Minister or the Chief Minister does not have the so-called disciplinary control. It depends on the government, depends upon the Prime Minister. Suppose if a strong Prime Minister like Modi or elder days Indira Gandhi, yes, she can remove him, she can take some action. But a Prime Minister, a weak and meek Prime Minister, of course I do not know the name, I do not want to mention their names. But if he is there, it is a play for the ministers, particularly in the coalition governments who came out with a wafer-thin majority. Then the minister will be very strong and he will be a deciding factor. Therefore, even though he utters something in the public, they cannot do anything. So this is the practical approach. Right. Supreme Court observed that the CM or PM does not have disciplinary control as a member over a member of the Council of Ministers. So, actually, these two petitions were filed. This Constitutional Bench was actually by 2017 or so, they wanted to put it before the Constitutional Bench. First issue is, it is a rape and dacoity case in Uttar Pradesh. It relates to crime number 838/16 under sections 395 dacoity, 397 so dacoity with deadly weapons, and 376D, that is gang rape, and IPC and section 7 and 8 of the POCSO Act, Prevention of Children from Sexual Offences Act. But when such a serious incident has occurred, immediately the police did not register case. It has taken a political overtone. So the then urban minister, UP Minister for Urban Development, so that is maybe Kishore. So he made out some outrageous statement stating that it is no such incident happened, it is only political conspiracy, how dacoity and rape can take place, all these things he has uttered very vociferously without knowing the consequences. Similar, not such incident, some minister in Kerala also, he also spoke as he liked. So therefore, Advocate Kalishwaram Raj, he made a suggestion before the bench that the Prime Minister as well as the Chief Minister should be allowed to take appropriate action against the erring minister. The court rejected this suggestion, saying it as fanciful. Do you think that? No doubt. So then we'll come back. We'll come to the topic or discussion made by the Honorable Supreme Court of India, because they have taken the help of the amicus curiae also. They stated that, Supreme Court ruled that the CM or PM does not have any disciplinary control over the ministers. So it's quite common. A strong CM or a strong PM can drop a minister out of the cabinet. But in case of multi-party system and coalition governments with a wafer-thin majority, so it is not possible. This what. Sometimes individual ministers, they are strong enough to decide the survival of the government. This problem is not unique to our country. It's there everywhere where the coalition government is there. So therefore, ప్రైమ్ మినిస్టర్ కానీ సీఎం కానీ ఎవరన్నా మినిస్టర్ బయటకు ఏదన్నా ఎక్కువ మాట్లాడినా ఓవర్ యాక్షన్ చేసినా సస్పెండ్ చేయటం లేకపోతే డిసిప్లినరీ యాక్షన్ తీసుకునేటువంటి అధికారం లేదు. సో ఇప్పుడు ప్రైమ్ మినిస్టర్ కానీ పవర్ఫుల్ అయితే ఎస్ హీ కెన్ టేక్, అలాగే సీఎం పవర్ఫుల్ అయితే కానీ వీక్ అండ్ మీక్ సీఎంస్ అయితే ఏమీ చేయలేరు. సో దేర్ ఫోర్ ది సో ఆఫ్ కలెక్టివ్ రెస్పాన్సిబిలిటీ ఇట్స్ ఓన్లీ ఏ పొలిటికల్ కాన్సెప్ట్. Right? It is only for the decisions taken as the Council of Ministers. The act of commission and omission, for that only they are helpful. Each minister is collectively liable for the decisions collectively taken. But just like our tort, that is vicarious liability. So Prime Minister is not held for the activity of the ministers. So Prime Minister does not have control over the ministers. No tortious liability or no vicarious liability. This is what is held by the Honorable Supreme Court of India. Because, so that means to conclude what the Supreme Court has said, ministers, they are also liable just like ordinary persons, just like Article 14. So he has got the so-called privilege and immunity when he speaks inside the assembly or inside the parliament. But outside, if he makes any statement, he is liable just like an ordinary person. So now the tort of reservation can be filed against him. But see, as far as the disciplinary matter is concerned, the CM does not have control over the ministers. So, okay, and here in this connection, the code of conduct, it is also self-regulatory, just like press, just like judiciary, it's only self-regulatory. So, minister, of course, they are not expected to violate the code of conduct. If they do so, they can be taken action just like ordinary person. This is a beautiful judgment. మీకు అర్థమైంది అనుకుంటున్నాను. జాగ్రత్త అండి. సహజంగా ఏంటంటే ఈ ప్రైమ్ మినిస్టర్ని సీఎంని వాడు అట్లా మాట్లాడేవాడు మినిస్టర్ని తీసేయి లేదా సస్పెండ్ చేయి అంటానికి లేదు. ఇదనమాట అల్టిమేట్. బికాస్ ద కలెక్టివ్ రెస్పాన్సిబిలిటీ ఈవెన్ దో ఇట్స్ ఎ కాన్స్టిట్యూషనల్, ఇట్ ఈస్ ఓన్లీ ఏ పొలిటికల్ కాన్సెప్ట్. ఎందుకంటే పవర్ఫుల్ మినిస్టర్స్ పిఎంను మార్చేవాళ్ళు ఉంటారు. సో ఆ స్టేజ్ కాబట్టి పిఎం డస్ నాట్ హ్యావ్ ఎనీ సూపర్వైజరీ అథారిటీ. బట్ ఎనీవే, సో ఇఫ్ హీ డస్ ఎనీథింగ్ రాంగ్, డెఫినెట్లీ యూ కెన్ టేక్ యాక్షన్ యాజ్ అన్ ఆర్డినరీ మ్యాన్. బికాజ్ ఓన్లీ ఇమ్యూనిటీ అసెంబ్లీలో మాట్లాడుతున్నాం, లోపల మాట్లాడుతున్నాం, బయటకు వస్తే రాదు. సో ఇఫ్ యూ నో దిస్ మచ్, ఇట్ ఈస్ సఫిషియంట్. థ్యాంక్ యూ.